The U.S. Supreme Court has just issued a major ruling in the challenge to a New York gun law.
Major Supreme Court ruling.
Most significant case regarding the Second Amendment in more than a decade.
The Supreme Court will be taking up a gun rights case.
Members of the Senate are focusing on gun rights in the wake of the Supreme Court's Brewen decision.
Major ruling involving the Second Amendment.
The Supreme Court has just issued a major ruling.
Major Second Amendment case.
Major Supreme Court ruling.
It's a case that legal experts will be watching closely.
The law the Supreme Court justices have their eye on is one that prevents people from carrying guns in certain public places.
And today, the Supreme Court has answered that question by a vote of 6-3.
Justices ruling this morning it conflicts with the Second Amendment's right to bear arms.
My response to that is that's the same claptrap that they have been using for 20 years.
You couldn't get a firearm and carry it just because you wanted to be protected against criminals. We won't see changes overnight, but it's going to be quick.
And today, the Supreme Court said that's unconstitutional. That puts a limit on the right to have a gun.
Everybody has a right if they're a responsible adult.
The right to keep and bear arms shall not be infringed.
This case could reshape how far states can restrict your right to carry and wear.
3 states just watched their entire permit system collapse overnight. Mandatory training requirements that took months and cost hundreds of dollars are being challenged in federal courts as we speak. Background check delays that stretched into weeks are suddenly under constitutional scrutiny, and gun owners who've been denied carry permits based on a sheriff's subjective opinion now have the strongest legal ammunition they've ever had. The Supreme Court just handed down a 6-3 decision that didn't simply settle one case. It created a constitutional framework that puts every gun restriction passed in the last 50 years on notice. If you carry, if you train, if you've ever been frustrated by bureaucratic obstacles to exercising Second Amendment rights, what just happened affects you directly. This isn't theoretical. Lawsuits are already being filed in Illinois, Massachusetts, California, and New York using this ruling as foundation. Federal judges are issuing injunctions forcing states to comply, and the legal landscape is shifting so rapidly that what was illegal last month might be constitutionally protected today. The case itself revolved around whether states could force law-abiding citizens through extensive permit delays and mandatory just cause requirements before allowing them to carry firearms. The court's answer was unequivocal, no. And in delivering that answer, they reinforced and expanded the Brewen precedent from 2022, creating what legal scholars are calling the new anchor for every Second Amendment legal fight moving forward. The decision reaffirms constitutional carry as the baseline standard. Any law requiring citizens to prove need or good cause for exercising their rights is now on extremely shaky legal ground. The court cited historical tradition as the key test. If a restriction wasn't imposed during the founding era, states need compelling evidence to justify it today. This standard restricts states from burdening fundamental rights with bureaucratic permission slips. With this one decision, the court reminded every state that the Second Amendment is not a second-class right. It stands equal to the First Amendment, the Fourth Amendment, and all others in the Bill of Rights. Before the Brewen decision in 2022, states like California, New York, and New Jersey operated under what's called a may-issue system for carry permits. Even if you passed the background check and completed required training, authorities could still deny your permit based entirely on their subjective judgment of whether you demonstrated sufficient need. This Supreme Court ruling directly dismantles that philosophy, declaring that subjective discretion has no place when fundamental rights are at stake. New York's good cause standard has been invalidated. California's sheriff approval requirement is on the chopping block. Hawaii and Maryland's restrictive systems are under direct legal attack. Courts must now demand historical analogs for restrictions, not modern political preferences or bureaucratic convenience. States now face a legal reckoning. Either revise laws to comply with this constitutional framework or risk having them dismantled piece by piece in federal court. For gun owners, this means your rights don't stop at your county line, and they can't be denied based on a government official's personal opinion about whether you need to exercise them. One of the most insidious tactics anti-gun jurisdictions have employed is deliberate permit processing delays. Some counties take 3, 6, or even 12 months to process carry permits. That's not enforcement, that's obstruction. This new ruling challenges those timelines by framing the right to carry as immediate and active. You don't wait 8 months to exercise your freedom of speech, and you shouldn't have to wait that long to defend your life. Courts are now reviewing permit processing delays as potential constitutional violations. Denying timely access is being recognized as a burden on core constitutional rights. Lawsuits have already been filed in states like Illinois and Massachusetts specifically targeting these delays. Plaintiffs are seeking fast-track injunctions to force state compliance. The clock just became the enemy of anti-gun regulation. If a state deliberately drags its feet on permit processing, federal courts may intervene with orders forcing immediate compliance. Gun control advocates have long favored mandatory training as a way to create barriers to carry access. But the court's decision didn't stop at permit systems. It also addressed whether mandatory classes, range time requirements, or expensive certification programs could be used to suppress carry rights. The answer: if similar training wasn't historically required at the founding, it's constitutionally suspect today. Modern training requirements are now being tested against historical precedent. Courts are rejecting laws with no 18th or 19th century equivalent. This affects Maryland, California, Connecticut, and other states with strict training regimes. Lawsuits are challenging the costs, wait times, and certification complexity built into these programs. This doesn't mean training is bad or unnecessary. It means government cannot make training a barrier to exercising a constitutional right, especially when courses cost $500 plus and require 6-week waits. The distinction is crucial. States can encourage training, offer free or subsidized training, even make training a condition for enhanced permits with additional privileges. What they cannot do is make expensive, time-consuming training an absolute prerequisite for basic constitutional rights. The court's ruling didn't eliminate background checks, but it sent a clear warning. They must be fast, fair, and consistent. Delays caused by NICS system errors, pending statuses, or state-level bureaucratic holdups now risk violating the timely access requirement established in this decision. This shifts the burden of proof fundamentally. You don't have to prove your innocence. The system must prove your ineligibility, and it must do so quickly. Pending NICS checks beyond 3 business days are now under constitutional scrutiny. States adding additional background checks beyond the federal system face legal challenges. Gun store holds based on discretionary concern may be illegal under this framework. Systems like California's mandatory 10-day waiting period and Washington's permit to purchase requirements are being legally reevaluated. The message is unmistakable. Background checks must be efficient, not punitive. If the system can't deliver results promptly, it cannot be trusted as a gatekeeper for constitutional rights. For years, states have required extensive layers of mandatory training to receive carry permits. But after this ruling, the entire concept faces serious legal threat. The court signaled that overly burdensome prerequisites, even when framed as public safety measures, may violate the Constitution when applied too broadly. States like Maryland and New York require up to 16 hours of training for permits. These requirements may be ruled excessive under the new constitutional standard. California's complicated multi-step process could face substantial rollback. Some states may be forced to shift from required training to recommended training models. The ruling makes clear that rights don't depend on jumping through arbitrary hoops. The state cannot set barriers between citizens and constitutional rights simply because those barriers seem reasonable to legislators or administrators. That principle is already shaking up state legislatures across the country as lawmakers scramble to revise laws before federal courts strike them down. This ruling triggered fresh debate about federalism. When state gun laws contradict the Second Amendment, who wins? The court made its position crystal clear. Constitutional rights don't stop at state lines. States that continue passing restrictive laws now risk swift federal judicial intervention. Even federal policies are being examined under the same originalist standard. Expect more cases fast-tracked to the Supreme Court, with this decision acting as the controlling precedent. The balance of power is shifting not in theory, but in real-world cases hitting federal dockets every week. You might remember New York State Rifle and Pistol Association versus Brewen as a landmark 2022 decision. This new ruling builds on Brewen and cements it as the controlling framework. Brewen said the government must prove laws align with historical tradition. This decision strengthens that standard, making it substantially harder for states to invent modern restrictions without historical precedent. Laws must now survive strict scrutiny under the lens of original constitutional intent. The Brewen test is no longer just guidance. It's judicial armor protecting Second Amendment rights. Every gun case from here forward will be judged under this precedent, and any state law that fails to meet this historical standard is operating on borrowed time. Lower courts that previously found creative ways to uphold gun restrictions despite Brewen are now finding their decisions reversed on appeal. The message from the Supreme Court is being heard. Apply this standard rigorously or expect reversal. This isn't just a legal moment, it's a cultural reset. Gun owners, lawmakers, and activists are all recalculating their strategies. Lawsuits are being filed nationwide using this ruling as foundation. Pro-gun states are expanding constitutional carry while gun control states face difficult decisions about which laws to defend and which to abandon. The ATF's regulatory approach will be closely watched, especially after recent attempts to expand definitions and create new restrictions through administrative action rather than legislation. Expect new bills in state legislatures, both expanding gun rights in red states and attempting creative workarounds in blue states. Expect new legal challenges testing the boundaries of this framework. The Supreme Court didn't just issue a ruling, they established a constitutional revolution that's still unfolding. Gun rights organizations are identifying which restrictions to challenge next. State attorneys general are reviewing which laws remain defensible under this standard. And gun owners who've lived under restrictive regimes for years are finally seeing pathways to exercising rights they've been denied. The court has spoken with unusual clarity. Rights don't wait for permission slips. The burden now sits squarely on government to prove its case using historical evidence, not modern policy preferences, not public opinion polls, not claims about what makes officials feel safer. For years, gun owners have played defense, fighting to preserve rights against steady erosion through legislation and regulation. But after this ruling, the momentum is shifting. Laws that seemed permanent fixtures are suddenly vulnerable. Restrictions that appeared untouchable are facing constitutional challenges with real prospects of success. This is the beginning of a new chapter in Second Amendment jurisprudence. The full implications will unfold over months and years as lower courts apply this framework to hundreds of challenged laws. Some states will comply promptly. Others will fight to preserve restrictions until forced to abandon them by federal court order. But one thing is certain, the legal landscape just fundamentally changed, and gun owners finally have the constitutional framework they've been seeking for decades. That's it for today, folks. See you in the next video.